Good morning. My name is John Tandler. I'm an attorney based in Denver, Colorado with the law firm of Sherman and Howard, and I practice publishing, intellectual property, technology, and business law. I'm pleased to present a program this morning for the Colorado Writers Collaborative on publishing contracts. This program is for authors, either would-be authors or already published authors who in their careers may be required to review an agreement with the publisher they propose to publish with. So let's get to it. I have a slide deck for today. I'm very happy to send it to you. My email address is on the last page of the slide deck. Please feel free to send me an email and I'll be happy to send you the deck. So we have, we're going to cover several topics today. First, general intellectual property laws, copyright, and how they relate to the scope of rights granted in a publishing agreement. We're also going to talk about the duration of publishing agreements, how long they are, and relating to that, how rights can be reverted under certain circumstances. Also, reps and warranties and indemnification provisions publishers typically require of authors, manuscript specifications and acceptance, as I said, reversionary provisions, competitive works provisions. I'm going to make a few comments about hybrid arrangements, and then an overall wrap up with thinking about evaluating whether a publisher is a good fit for you as an author. So copyright, which is the gravamen of book publishing and book publishing agreements, exists in original works of authorship fixed in a tangible medium of expression from which that work can be perceived, reproduced, or communicated. Copyright subsists in many kinds of different authorial creative works, be they literary works, artistic works, graphic works, sculptural works, computer source code, architectural drawings, many other different kinds of works of authorship. Today we're focused on literary works, and the rights attendant to ownership of copyright give the copyright owner, who is the original author of the literary work, the full exclusive rights to reproduce the work, to license the work, to create translations of the work, and the author of the literary work is the sole and exclusive copyright owner and the owner of all those rights. And the point of the publishing agreement is for it to be the tool by which the author grants the publisher various rights to publish a book in book form. So the scope of rights clause is very important to a publishing agreement, and as well the ability for the publisher to create derivative works. Now, derivative work, and again, I'm speaking about the scope of rights clause in a publishing agreement and that which a publisher would typically ask an author to give the publisher rights to, which includes derivative works. A derivative work is an adaptation, modification, translation, a work in which an initial work can be recast, formed, or adapted. Publishing agreements want the rights for publishers to create derivative works so the publisher can monetize your literary work in various forms and formats. So a publishing agreement's scope of rights provision is important to review, it's important to understand, it's important that a publisher monitors those rights on an active basis going forward. Now, speaking of actively monetizing those rights, publishing agreements have a very long duration. Typically, I should say, customarily, in the industry traditionally, publishing agreements are for the term of copyright. And the term of copyright in the work, and when the work is written by an individual, under today's copyright laws, the term of copyright is the author's life plus 70 years, which is obviously a very long time. And so the duration of a publishing agreement is typically tailored or restricted by provisions which state that A, if the publisher or the author is in breach and there are grounds to terminate the agreement, either party can terminate it. Another example is if the publishing agreement has a provision for the publisher that it requires the publisher to publish the work within 12 or 18 months after manuscript acceptance. If that date is not met and any extensions are not met, then the author has the right typically to revert the rights and terminate the agreement. There are some other reversionary provisions to agreements which I want to talk in a few minutes about, but those are the basic rubric of having a long agreement and then the ability to terminate it both on the publisher's part and the author's part if certain conditions don't occur. There's one other provision in the Copyright Act I want to mention, which is Section 203. It's a very interesting provision of the Copyright Act which permits grantors of exclusive rights to, if they follow very, very detailed statutory procedures, to pull back those rights within time periods of around 35 years after the date of grant. This provision, as I said, it's Section 203 of the Copyright Act of 1976, is germane 35 years out from the onset of a publishing agreement or other kind of assignment of rights. It does not apply to work made for hires. On to contract representations and warranties. And again, all the material I'm providing today is on my deck, and I'm happy to send it to you. Just send me an email. So publishing agreements typically have reps and warranties in them. They always have them, frankly. And they're intended to be one aspect of the publisher's diligence to make sure that the manuscript is in publishable form and that the author has the right to publish the manuscript and it doesn't violate any rights the author has granted to a third party. So a publishing agreement typically has a series of reps and warranties, representations and warranties, by which the author confirms for the publisher that he or she has all the necessary authorization and rights to sign, deliver, and perform the agreement, that the work is original and that it's not been published. And if there are any exceptions to the work being original or not having been published, the author is to call those out. And that the work doesn't infringe upon the intellectual property rights of a third party or any privacy rights of a third party or any other third party proprietary rights. So it's up to the author in signing an agreement and reviewing an agreement before the author signs it to ensure that he or she can make comfortably those reps and warranties. As an example of an item that would need to be taken care of before an author signed an agreement with reps and warranties like that is to ensure that the author is obtaining all of the necessary clearances for photos, other third-party content for the work so that there are no infringements of third-party intellectual property rights. So the ability to review and sign a publishing agreement proposed by a publisher is in part looking at the language itself and making sure the author can comply with the language, but likewise, it's ensuring in the first instance the manuscript is in good condition for at least submission to the publisher and that there are no legal problems or problems which would be a breach of an author's representations and warranties. Now on to manuscript specifications. In the same way that the author wants to ensure that it can comply with the reps and warranties of the publisher, both parties have a great interest in aligning on the manuscript, on its specifications, and those in turn depend upon what kind of literary work one is discussing. Specifications may be at a more macro level, content, quantity, page count, word count, things of that nature for a novel or a fictional work, whereas specifications might be much more detailed for a how-to publication, such as how to teach a particular area of instruction, or a recipe book, or a safety manual of sorts. So in that kind of, or a mapping or geographic text, in those sorts of books, which have more graphs, potentially maps, charts, measures, things of that nature, the specifications might be more detailed. So whether you're on one end or the other end of the spectrum, it is important from the onset of the project and frankly during the course of a project to have alignment on manuscript specifications, and the publishing agreement should set those forth in the necessary amount of detail. Likewise, the publishing agreement should set forth the standards by which the publisher can review and make comments on or otherwise reject the manuscript or provide it back to the author for edits. And those criteria can be compliance with the specifications, adherence to a table of contents, a prescribed or discussed or collaborated table of contents, compliance with the representations and warranties in the agreement. Those types of items are the items that a publisher would review and evaluate in terms of manuscript acceptance and polishing it up for publication. Now, changing course a bit, I want to talk about royalties and royalty statements. Royalties, in essence, are the measure by which an author or other content provider that licenses his or her creative work gets paid. A royalty is a percentage of a publisher's proceeds from sale of the book or licensing rights to the book. The percentage is basically expressed in terms of a numerical percentage as compared to the revenues, the net revenues after returns the publisher brings in on book sales. Royalties are important to follow and track in the form of reviewing statements from publishers setting forth book sales, earnings on those book sales, and correlative royalty payments to the author. The more detail on a royalty statement, the better. The more detail provides the author information about where a book is selling well and maybe where it's not so selling well. That can be supported in a better way or in a different, or a better way in a particular channel. So authors are encouraged to carefully review royalty statements, understand what they say, take the information from them and use it to your benefit. And if there are questions or items that one does not understand on a royalty statement, ask the publisher, ask the editor. Publishing agreements often have provisions that enable authors to periodically audit publishers' records relating to book sales, and that is something that is a very customary provision in publishing agreements. Now we get to what I mentioned a little while ago, out of print and reversion clauses. We spoke earlier about the length of publishing agreements, that they're typically for the term of copyright, which is the author's life plus 70 years. Well, that's a super long time, and you as an author, and frankly as a publisher as well, do not want a book to lie fallow, do not want the rights that are attendant to copyright not to be exercised, and for the book to lie fallow and not make any earnings. So when a publisher decides that a book is no longer appropriate for its catalog, or it doesn't continue to reprint it, or it doesn't make it available as an ebook, or it does not make it available as a print-on-demand book, one or more of those conditions are in essence the publisher is putting the book out of print, and a publishing agreement, when that occurs, should provide the author with the right to contact the publisher and say, let's either reprint or have my rights revert. And that's called an out-of-print provision or a reversion clause. So this is a very important part of your agreements. If a book doesn't perform well, whether for whatever reason, it's typically appropriate to get one's rights back to decide what to do with the content. And whether it's the book being not available in stock or not available as an ebook, or some agreements provide that the book must sell a minimum number of units per quarter or 6 months for the agreement to stay in effect, and if it does not, the author can request that the rights revert. And if that occurs, the author and the publisher, if the publisher agrees that it's not going to reprint the book and continue to publish it, then there should be a proper transition where there's a clear documented assignment of rights back to the author and a reversion, a complete reversion, so the author can do what he or she wants with the content, update it, revise it, and republish it if the author wants. Competitive works clauses. Publishers make large investments in their titles. Whether it's a small, short title or a larger, complicated book, typically there's a quantitative financial investment by a publisher in the title. And what the publisher does not want to see is that within some period of time, after the publisher has made the investment in the book, that the author has published another competitive work that would impinge upon sales of the author's original work. Competitive is a defined term, whether its content is substantially similar, whether it sells into similar sales channels with similar content, whether a reader's eyes are going to look at one book compared to the other on the bookshelf and decide they might purchase the latter book rather than the original book. But that is what the publisher is concerned about. So competitive works clauses, they're not non-competes. They're not intended to prevent an author from earning a living, but they're intended to say the author shall not prepare, write, work on a book that is deemed to be competitive with our original book, either for a period of time after the original release of the book or for the entire time that the publishing agreement is in effect. Clauses vary, but here again, it's also very important for the author to review these clauses carefully, understand the clause. If there are exceptions or carve-outs, or the author is engaged in blogging or writing professional articles, those should be expressly carved out. Sometimes provisions provide for a de minimis portion, a percentage of the verbatim content to be used by an author if appropriate credit is given to the publisher. But these provisions are really intended to ensure the publisher's investment in the book is somewhat protected and really work for the benefit of both parties if they're adhered to. A few comments about hybrid arrangements. Under the traditional publishing model, not the hybrid model, but the traditional publishing model, publishers really bear most of the out-of-pocket financial risk for publishing a book. That's not to take away at all from the hundreds of hours or thousands of hours it takes to write a book. But in terms of once the manuscript gets to that point where it's ready for publication, the publisher under a traditional arrangement is funding the publication costs, certainly the printing costs, hopefully some of the marketing costs, and the hard costs of distribution. And so the publisher is at risk for that investment, as I mentioned a moment ago about competitive works. So hybrid arrangements are typically, and these are generalizations, a little different than that. But a hybrid arrangement is where the publisher, the hybrid publisher, might pass off or require reimbursement by the author on some of these hard costs, whether they be the author paying for the printing or the author paying for cover design or things of this nature which are out of pocket but necessary to bring the book to market. So with the hybrid arrangement, the author is funding part of those costs typically. And those arrangements might be very suitable and very helpful for an author that otherwise would not get published. And so there are some excellent hybrid publishers out there who provide that service and market for those kinds of authors who want to get published, may not be able to get published with a traditional publisher, and can fund and are able to fund part of the cost of publication. And what I tell clients when I'm brought those arrangements is, let's review the contract carefully. Make sure you understand the history of the hybrid publisher. Make sure you understand the other authors it's publishing, understand the costs that you're going to have to bear throughout the arrangement, what the profit looks like, what the percentages look like, and really do a proper diligence on the project, because it is a business project because you are investing in it. So hybrid publishing can be an excellent source of publishing for those who who are able to fund that model and work well with a hybrid publisher and have an excellent publishable manuscript where they're willing to bear part of the risk of getting it out to market and getting it into the marketplace. I want to wrap up with just some general comments. First of all, these comments today are general. It's very important when presented with a publishing agreement to review it in detail, to read it carefully, to understand its terms, and if you do have questions about it, to make sure that you're speaking with the publisher and getting the proper answers to your questions. And relating to that, in addition to the contract, it's very important, and this is what this slide is about in this deck, to make sure that the publisher is a good fit for you. Talk to the people, talk to the editors. If you can meet with them face-to-face, that's a bonus. Certainly meet with them via Zoom in this environment. Understand what their processes are, understand what their expectations are, and that you can meet those. Understand who's on its front list and who's on its back list, and how strong its publishing program is. Get an understanding of the editorial process and the marketing and branding process and your own obligations relating to marketing and branding and how that's going to go forward. And make sure that you've got a clear expectation of the path ahead, because publishing a book is not an easy thing to do. It's hard work. And to work, and you want to make sure that by going on this journey and the hard work that you're going to be embarking on, that it's a good fit for the people that you're working with. I very much appreciate the opportunity to teach today. Thank you very much for your time. Good luck with your publishing activities. And again, if you would like a copy of the PowerPoint deck, my email, I'll just state it in case you can't see it easily, is and it's here on this slide, jtandler@shermanhoward.com. It's on this last slide. Thank you.